Hi, I'm Dr. Hart. This is my presentation for the Constitution Day 2024. The case I will be presenting is Culley versus Marshall, decided by the Supreme Court on May the 9th of this year. First, I would like to acknowledge a number of people whose participation traditionally in our Constitution Day has been crucial to making this day a success. Dr. Eric Davis, the Social Sciences Department Chair, Dr. Robert O'Mara, Events Committee Chair for the Social Sciences Department, Dr. Kenneth Fernandez, who is responsible for putting together our website and also a frequent presenter, and Dr. Francis Carlton, who's also been our frequent presenter in a number of past Constitution Days. So, with that said, Culley versus Marshall. This case pertains to the issue of civil forfeiture, which is controversial not just constitutionally but politically, and as a political science professor, I am most interested in the political controversy surrounding this case. So civil forfeiture is distinct from criminal forfeiture. In civil forfeiture, property is seized because it is connected to a crime. Now, probable cause is all that is needed to seize and ultimately to retain property in civil forfeiture cases. These are called in rem forfeitures because the property itself is the defendant. So no criminal charge against the owner is necessary to seize and ultimately to make the person forfeit property in civil forfeiture cases. Criminal forfeiture is different. Criminal forfeiture is punishment for a crime. So if you convict someone for a crime, it is possible to force them to cede some property. But in order to commit someone of a crime, the standard, as you probably know, is beyond reasonable doubt. This is a harder standard to meet than the preponderance of evidence standard required by probable cause. It's interesting that when it comes to politics, you can have unlikely ideological bedfellows in civil forfeiture cases. So liberals, for example, the Constitutional Accountability Center, which actually describes itself as a progressive think tank, and the Institute of Justice, which is a libertarian think tank, agree on civil forfeiture in that they are against it. And if they had their way, civil forfeiture probably would not exist. But in this particular case, the question is more narrow. The question in Culley versus Marshall is not whether or not civil forfeiture is unconstitutional. Rather, the question, as we will see, is whether or not a preliminary hearing, a retention hearing, is required before the big one, the real forfeiture hearing, is held. What about the facts of the case? On February 17th, 2019, Halimar Culley's son was pulled over by police while driving a car registered to his mother. Police arrested him, charged him with possession of marijuana and drug paraphernalia, and seized the vehicle. Culley unsuccessfully tried to retrieve the vehicle, and on February 27th, 2019, the state of Alabama filed a civil asset forfeiture action in state court. After 20 months, the state court granted Culley summary judgment, finding that she was entitled to return of her vehicle under Alabama's innocent owner defense. Culley filed a class action lawsuit in federal court, claiming that the failure of the state and local officials to provide a prompt post-deprivation hearing violated her right under the 8th and 14th Amendments. The district court ruled for the defendants, meaning for Marshall, and the U.S. Court of Appeals for the 11th Circuit affirmed, and as to the claims that were not moot. So the claim as to return of the property was moot. The claim that was not moot, whether or not property retention hearing should have been granted promptly after the seizure of property. Now, one thing that the state of Alabama clearly did well in this case was to file for forfeiture within 10 days after the seizure of the vehicle. So I don't know what the law was at the time in the state of Alabama as to the time frame of filing the initial forfeiture complaint post-seizure of the vehicle or any property, but at the federal level, Congress has codified it to 60 days. Here we see, far fewer than 60 days. 10 days to act for any state government is very, very quick. I think we would agree on that. So the reason why the delay occurred in this case, the reason why it took 20 months to recover the vehicle is because Culley waited for 6 months to act at all, to respond to that forfeiture complaint. So the state only took 10 days to make a forfeiture complaint. Culley waits 6 months to file her response, and then over a year to take the next action. So the delay really was mostly her fault. But the delay here is not really a question. The question again is whether a retention hearing before the forfeiture hearing is required. The Culley case is really a consolidation of two cases. The other case, also out of the state of Alabama, is Sutton versus Leesburg. Lena Sutton's friend ran on an errand with her car. While the friend was still driving, Leesburg police pulled him over and found methamphetamines in the car. The police arrested him and seized Sutton's car. Sutton successfully filed for a motion for summary judgment, and the police were ordered to return her car to her over a year after they'd seized the car. And again, the reason for this long delay in the Sutton case is the same as it is in the Culley's case, because the property owner, the innocent owner, the person to whom the car is registered and who is not driving it, is not connected to a crime, took a long time to respond to the state's initial forfeiture complaint. So the question is, what test must the district court apply when determining whether and when a post-deprivation hearing is required under the Due Process Clause, right? So this case was decided at the district court level against both Culley and Sutton. They each filed a lawsuit in the district court and in a different district court, one in the northern district court for Alabama, another in the southern district court of Alabama. But both district courts in their respective cases ruled against the claimants in this case. So the claimants appealed to the Court of Appeals. The Court of Appeals ruled against them, and the case reached the Supreme Court in this posture that they're both innocent property owners. They have an affirmative defense, and the only question is whether they should have been granted this preliminary retention hearing. Well, what does the Due Process Clause of the 14th Amendment say? It says, nor shall any state deprive any person of life, liberty, or property without due process of law. Deprivation of property potentially occurred in this case because they had no ability to use their property for a long time, partly because there was no quick preliminary hearing, and so they are suing to establish this right to a preliminary retention hearing. The Supreme Court had to determine which precedent to apply. The Supreme Court decided to apply the precedent of Barker versus Wingo, which is a four-pronged test borrowed from this case. The case itself has nothing to do with civil forfeiture. It is just being used by the court to establish or to use or reuse a test. So there are two ways that a court can apply a test. One is it can come up with a test out of its collective Supreme Court head, or it can reuse a test which they had created in a previous case. So what is this four-pronged test? First, the court has to consider the length of the delay. How long was the delay? Second, the reasons for the delay. Why has the delay occurred? What caused it? Third, the time and manner in which the defendant, or in this case claimant, because we are dealing with civil forfeiture here, has asserted his or her right. Fourth and last, the degree of prejudice of the defendant, in our context is going to be claimant, which the delay has caused. Right? So how much damage was caused to the claimant? What we see with this Barker test is whenever the Supreme Court decides to apply it, the decision tends to go against the claimant. In other words, if you try to establish as the claimant the loss, that you have suffered the loss of property, deprivation of property, if the court uses this case, you're likely to lose. And of course, the court decided to use this case, use this test in the Culley case, and Culley lost. The other alternative was to use the Matthews test. The Matthews test is also not from the civil forfeiture context. It's from the context of administrative law. More specifically, in the Matthews case, the court had to decide what process is due when someone's Social Security benefits are cut. So this three-pronged test tends to favor more extensive due process. All right, and so it's not surprising that Culley and Sutton wanted the Supreme Court to apply the Matthews test, but the Supreme Court declined that invitation and instead went with the Barker test. The Barker test had been previously used by the Supreme Court in two cases which the majority decision relies on very heavily to decide Culley. These two cases are United States versus 8850 and United States versus von Neumann. One footnote about the names of these cases. Sometimes the cases are named after property because property itself is the defendant. And so this is why you have cases with funny names like the United States versus $8,850 or the United States versus one Dodge Durango, etc. So in these two cases, which the majority opinion heavily relies on, in the first case, in the 8850 case, which was decided in 1983, in that particular case, the claimant suffered an 18-month delay. Vasquez lost the use of her $8,850 because she failed to declare this money when she was flying into the United States, and at the customs she was obligated to, according to federal law, to report any money over $5,000. She failed to do this. This money was seized and was not returned for 18 months because she was being investigated on two potential violations. First was a criminal violation because she was suspected of being a drug courier. Second, because she lied to the customs agents. And so the Supreme Court in the 8850 case ruled against Vasquez, holding that the 18 months delay was not a violation of the Due Process Clause under the Barker test. The second case on which the Supreme Court majority opinion heavily relies on Culley is called United States versus von Neumann. John von Neumann imported lawfully an exotic car from Switzerland to Vancouver, Canada. But then he drove that car from Vancouver to the United States, and when he crossed the U.S. border, he failed to declare the vehicle, and the vehicle was seized. Von Neumann petitioned for remission. Remission is basically a plea for clemency, plea for leniency. It communicates to the government, I messed up, but please pick me up. Oopsie daisy, my mistake. I should have declared it. Please, go easy on me. Give me back my property. Now, after von Neumann filed his remission petition, the government took 36 days to respond, and von Neumann claimed that delay was excessive. And the Supreme Court, applying the Barker test, ruled against von Neumann. So here you have these two cases. The majority opinion was written by Justice Kavanaugh, and 5 other justices joined in this opinion. The opinion emphasizes not so much the Barker test versus Matthews test. Rather, it emphasizes history and tradition which is a pattern with this court. So 6 main points. What are the 6 main points the opinion makes? First, Justice Kavanaugh refers to the Collection Act of 1789, saying that this particular act allowed for the forfeiture of ships, goods, and merchandise involved in suspected violations of the customs laws. And then he says, well, the Collection Act did not require a separate preliminary hearing before the forfeiture hearing, so no retention hearing. And then when this act was amended in 1790 and 1799, Congress also did not provide for a separate retention hearing. So this is going to be the pattern in Kavanaugh's opinion, emphasizing history. And so he chose to go back to the 1789, which is the very first year in which the government came into existence under this Constitution. The presidential election, the first presidential election, concludes in 1789. George Washington becomes the first president that year, and the first Congress meets in 1789. The Supreme Court still doesn't meet until February 1st of 1790. So here we clearly see that already in the very first year of our government under our Constitution, civil forfeiture was law, and civil forfeiture did not provide for a retention hearing. Then Kavanaugh goes on to say, well, many state forfeitures from the founding period similarly did not require a preliminary hearing before the forfeiture hearing. And then he says, in addition, when the 14th Amendment was ratified in 1868, because after all here we are dealing with the 14th Amendment, Congress did not require preliminary hearings. Congress provided that goods seized under a new revenue law should remain in the care and custody of the government until final judgment in a forfeiture trial. Okay? The government seizes, the government retains until final judgment of the forfeiture trial. None of the things with preliminary hearings here. Although that revenue law provided for bond, that is to say, you could bond your car or any of your property out, which, by the way, you could do in the Culley case because Alabama did allow for a bond. Although that revenue provided for a bond, it did not grant property owners a right to a preliminary hearings. So as far as hitting points on history and tradition, at least so far, the majority seems to be on a solid ground, right? Well, let's see how it goes. Number 4, many state forfeiture laws from around the time of the 14th Amendment likewise did not provide for a preliminary hearing. Number 5, petitioners and their amici do not identify any federal or state laws that before the late 20th century required preliminary hearings in civil forfeiture cases. And 6, which is a corollary of 5, really, a few states now require preliminary hearings. This is, I bolded, the bolding of now is mine. Our decision today does not preclude those legislatively prescribed innovations. Rather, our decision simply addresses the baseline protection of the Due Process Clause. Fair enough. In civil forfeiture cases, the Due Process Clause requires a timely forfeiture hearing, but does not require a separate preliminary hearing. So you can see the reactionary element here in the current court, in that it seems to see anything that happened starting in the second half of the 20th century, especially since like the mid-1960s, as at least constitutionally suspect, if not constitutionally illegitimate. So and we saw that in cases again and again. We saw it in Nyserpa versus Bruin, the case which I did for the 2022 Constitution Day. We saw it in a number of cases. The Supreme Court saying, history and tradition, that's really the olden days. That's the 18th century. That's the 19th century. Don't come to us saying that there's a tradition here, which is much more recent, of governmental regulations. All of those things, they're innovations. They're not really new. That's the 60s, the 70s, the 80s. No. That's almost brand new in the historical analysis of this court. So what I would like to suggest here is the majority argues not so much, in effect not at all, over Barker test versus Matthews test. And it really is not truly using the originalist approach. What is the original meaning of the text? And it's not using textualism. What does the black letter law say? It's using history and tradition as it understands it. And the way that it understands it, again, go back to the 18th century, consider 19th century, but definitely cut the line when it comes to the late 20th century. And this is how we are going to proceed. This is where this court seems to be headed, not just with this decision, but with the way it decides important cases in general. Then we have concurring opinion. The concurring opinion, authored by Justice Gorsuch and joined by Justice Thomas, to me is the most interesting of the three opinions in this case. It reads more like a dissent. And it's fascinating in the sense that this opinion tends to see the history that the majority postulated and then raise it even more history. I'll see your history and I will raise you super history, older history. Most civil forfeiture laws, writes Justice Kavanaugh, are pretty new. As part of the war on drugs in the 1970s and 1980s, Congress began enacting sweeping new civil forfeiture statutes, allowing the government to seize and keep the proceeds of drug crimes and the personal property used to facilitate them. Today, it appears white-collar and firearm crimes now account for the larger share of all federal forfeiture than drug crimes. So first of all, Kavanaugh tries to establish a different baseline. He says he understands that, yes, certainly there were forfeiture laws all the way back in the 18th century, but look, most of them are pretty new. So the baseline that he tries to establish is with most. When do most forfeiture laws originate? Not in the 18th century. They go back to the Nixon administration and the drug war, and then the 1980s with Ronald Reagan's revival of the drug war and putting it on steroids, so to speak. And even that, suggests Gorsuch, is not enough, because most of the forfeitures today have nothing to do with drugs. In fact, they appear to be white-collar and firearm crimes. Okay, very interesting. So civil forfeiture has become a booming business. We are seeing here an innuendo, an insinuation that points at possible corruption within law enforcement, or at least motives that are suspect, that are constitutionally and maybe morally suspect. In 2018, federal forfeitures alone brought in $2.5 billion. Meanwhile, according to some reports, these days up to 8% of civil forfeitures are not accompanied by criminal conviction. Of course not, because they don't have to be. Because criminal prosecutions cost a lot of money, because they use a higher standard, reasonable doubt, to convict a person. It's easier simply to seize and then win a forfeiture hearing under the probable cause standard and have done. So it's not surprising. 80% of civil forfeitures are not accompanied by any criminal conviction. All right, very interesting. Justice Gorsuch continues. Law enforcement agencies have become increasingly dependent on the money they raise from civil forfeitures. The federal government shares a large portion of what it receives with state and local law enforcement agencies that aid its forfeiture efforts. At one point or another, about 90% of these agencies serving jurisdictions with populations above 250,000 have participated in these equitable sharing schemes. Not only do law enforcement agencies have a strong financial incentive to pursue forfeitures, those incentives also appear to influence how they conduct them. Some agencies, for example, reportedly place special emphasis on seizing low-value items, relatively small amounts of cash, hopeful their actions won't be contested because the cost of litigating to retrieve the property may cost more than the value of property itself. Other agencies seem to prioritize seizures they can monetize rather than those they cannot, posing, for example, as drug dealers rather than buyers, so they can seize the buyer's cash rather than illicit drugs that hold no value for law enforcement. Justice Gorsuch continues, contributing to the inducement to settle is how little proof the agencies must produce to win forfeiture, the cost of litigation, and the need to appear in court sometimes, as Ms. Culley learned, in a different state. So Holly McCauley was a resident of Georgia. The car that was seized was driven by her son, who was attending college in Alabama. And if these tactics and burdens work against all affected individuals, can it be any surprise the poor and other groups least able to defend their interests often suffer most? So here we are in the realm of sociology. The Supreme Court now speculates, or at least I should say Justice Gorsuch speculates, logically so, that it is the poor who are affected the most, negatively affected the most by these forfeitures. But then his tone changes and he drops some of the formality with which his opinion and most Supreme Court opinions are written and channels his inner Justice Scalia, I would suggest, whom he after all replaced on the Supreme Court in 2017. Justice Scalia is famous for writing passionate, vehement, sometimes informally styled dissenting opinions. This is a concurring opinion, but with concurrences like Gorsuch's, I wonder if you need dissents. So listen to what Gorsuch is writing. Really, it's hard not to wonder whether some current civil forfeiture practices represent much less than a revival of the archaic common law deodand. Here's a dictionary word that you may want to look up. The deodand required the forfeiture of any object responsible for a death, say a knife, a cart, a horse, to the crown. Today, the idea seems much the same, even if the practice now sweeps more broadly, requiring almost any object involved in almost any serious offense to be surrendered to the government in amends. The hardships deodand often imposed seemed more than faintly familiar too. Deodands required forfeiture regardless of the fault of the owner himself, who was sometimes deceased. Not infrequently, the practice left impoverished families without the means to support themselves, faced not only with the loss of a loved one, but also with the loss of a horse or perhaps a cart essential to their livelihoods. As time went on, two curiously familiar financial incentives wormed their way into the system. Ultimately, the deodand's appeal faded in England, and this court has held that it did not become part of this country's tradition, part of the tradition of this country, but has something not wholly unlike it gradually emerged in our lifetime. So you see, not only the informal tone and the passion in this part of Gorsuch's opinion, but you see a very interesting tactical move. I see your history, and I'm going to go back around it. I'm going to wheel all the way back around it and strike you from behind, from even deeper history, from even older history. You want to talk about tradition? Civil forfeiture really has its root. It springs from this deodand tradition, where a tool which was connected to a crime had to be forfeited to the crown, even when the owner was innocent, even when the owner was dead. We have rejected this tradition. In fact, what you, the majority, present as history isn't full history. It's not false history. It's not inaccurate. You are not lying because, after all, I'm joining this opinion. Again, I want to stress this is not just a 6-3 decision. This is a 6-3 opinion. Both Gorsuch and Thomas joined Kavanaugh's majority opinion. It's not like we have a plurality opinion and a majority decision. We have a majority decision and majority opinion. So, majority, your history is accurate, but it's not full history because I can go further back and show you how problematic civil forfeiture really is. Dissenting opinion by Justice Sonia Sotomayor echoes the same thing and adds an element of identity politics. So here we are in the realm of sociology and politics that also involves identity politics. Here's what Justice Sotomayor wrote, and Justices Kagan and Jackson joined in her dissenting opinion. Police agencies often have a financial incentive to seize as many cars as possible and to try to retain them. The forfeiture revenue is not a supplement. Many police agencies, in fact, depend on cash flow from forfeitures for their budgets. These cash incentives not only encourage counties to create labyrinthine procedures for retrieving property in the hopes that the innocent owner will abandon attempts at recovery, they also influence which laws police enforce, how they enforce them, and who they enforce them against. Police officers have an incentive to enforce the law in a way that leads to the recovery of fungible property, like cash or cars. Police officers might target low-level drug possession in cars instead of drug transactions on the street so that they can seize the vehicle, again, pointing toward less than pure crime-fighting motives. Instead of, street transactions, try to target vehicles because then you can seize the vehicle. A police officer cannot sell recovered marijuana, and a prosecutor's office does not ordinarily pursue low-level marijuana offenses. When a police department can recover the proceeds from a car civilly forfeited in connection to a low-level marijuana offense, targeting that offense becomes more appealing. She continues, moreover, officers have a financial incentive to target marginalized groups. Okay, here we get into sociology, such as low-income communities of color who are less likely to have the resources to challenge forfeiture in court. In 2019, a 2019 study found that the seizure of non-narcotic property from Black and Hispanic arrestees increases with the size of the budget deficit in the states where police departments can retain revenue from seized property. These same groups are often the most burdened by forfeiture because they are more likely to suffer in the daily lives while they litigate for the return of a critical item of property, such as a car. For many people, loss of access to a car, even temporarily, is significant. Over 85% of Americans drive to work. Unsurprisingly, studies have found a link between the inability to drive and the loss of a job. Loss of a car not only takes away one's ability to commute, but also imposes a barrier to buying necessities, accessing health care, and visiting family members, pharmacies, grocery stores, etc. Given these burdens, low-income communities are also the most vulnerable to pressure from unchecked prosecutors who can use coercive civil forfeiture processes to extract settlement money from innocent owners desperate to get their property back. All right. Some of the interesting tells that we get from the oral arguments. The oral arguments here lasted 1 hour and 40 minutes, which is unusually long for the Roberts Court. Roberts really keeps tight tabs on the time. And it's interesting that here, in addition to the claimants and to the state of Alabama, which is the respondent in this case, you also have the unusual move of allowing the federal government to make an argument, and that was done at the end of the proceeding by Nicole Reeves, who is Department of Justice Assistant to the Solicitor General, and her 19-minute argument, of course, supports the position of Marshall, Attorney General for the state of Alabama. So the reason why the Supreme Court allowed this rather unusual move is obvious, because after all, the due process clause of the 14th Amendment parallels the due process clause of the Fifth Amendment. And behind the narrow question of the Culley case, whether or not a retention hearing is required, looms a larger question, whether or not civil forfeiture itself is constitutional. And this can come up either under the Fifth Amendment or the 14th Amendment. It's just that this larger question is not the question of this case, but it's there in the background. And if you If you ponder this, it's very clear that this is the case. Um, so, my conclusion. Now, I wonder whether before I sort of read this formal conclusion, whether I have any thoughts on the merits of Culley's and Sutton's request in this case. Because if you are left with a strong impression of Gorsuch's opinion and Sotomayor's opinion, it may sound like really Culley should have won the case because she has a better argument. But I kind of want to bring this down to earth a little bit. Um, the thing to understand here is that Culley and Sutton are asking for an almost immediate preliminary hearing, which is reminiscent to the arraignment process in criminal context, but with additional rights. So, if you're arrested for a crime based on probable cause, very quickly, usually within 48 hours, you're entitled to an arraignment hearing. And in that hearing, charges against you would be explained and you would plead guilty or not guilty to those charges. And that's just about the extent of the hearing. What Culley and Sutton are asking for is not just a prompt hearing just like that, but also a hearing that would allow to contest the veracity of probable cause, whether probable cause to seize forfeiture really existed, to seize property really existed. They want this hearing to be adversarial. That is to say, they want to be able to cross-examine witnesses and participants. And they want to be able to actually state an affirmative defense. In other words, they want not just like an arraignment hearing, they want a mini trial before the trial. So the retention hearing to answer the question whether or not the innocent owner should be able to retain property, whether the person is innocent and therefore can retain property, really kind of a backdoor to hold a nearly instant trial. Because in a criminal context, arraignments do not allow you to cross-examine the prosecution and witnesses. You just plead guilty or not guilty. So they have asked for a lot, and the Supreme Court gave nothing. The Supreme Court said no preliminary hearing is required. So this decision is not a victory for property rights, but it may be a victory for crime fighting. There is something to be said that civil forfeiture is an effective tool of crime fighting. The argument on the other side, Sotomayor's argument, and to a lesser extent Gorsuch's argument, is that innocent owners sometimes get clipped. They sometimes become victims of somebody else's crime because they lose their property. But again, civil forfeiture, precisely because the standard is only probable cause to forfeit it instead of beyond reasonable doubt, is an effective tool of crime fighting. The fact that the police uses it to also maximize its revenue doesn't automatically mean that these tactics of maximizing cash revenue are contrary to crime fighting, contrary to reducing crime. The court's decision highlights the traditional conservative-liberal ideological division. In other words, the decision split 6-3 is probably what you would expect from the traditional conservative-liberal division, but the three opinions, if you look at the three opinions as I explained them earlier, majority, concurrent, and dissenting, they reveal a wider ideological spectrum and a more fractious court, because you definitely see a libertarian streak in what Justice Gorsuch wrote in his concurrent opinion. And again, he channels his inner Scalia, who also had a libertarian streak, in addition to his, I think, stronger current of thought, which was more in line with conservatism and state interests. But here, just as Scalia did in a number of important cases, you see Gorsuch's libertarian streak. So the three opinions reveal what the decision doesn't reveal, and that is that the court is fractured along the liberal, conservative, libertarian approaches to civil forfeiture. Finally, civil forfeiture is useful in the international context because you may want to seize money, equipment, and personal property of terrorist groups, like let's say like Hezbollah, or property of Russian oligarchs. Might we see the day when the Supreme Court declares civil forfeiture unconstitutional in the domestic context, but constitutional when it comes to international crime? I don't know, but the decision is a bit unsettling. For now, civil forfeiture is safe. Civil forfeiture is constitutional. In the foreseeable future, its constitutionality will not be overthrown, but we would definitely see the problematic elements associated with it, the burden it imposes on innocent owners, the burden it imposes on poor people, and the appeal that it has in terms of fighting crime, especially in the international context. So that's my presentation. Thank you.